I want to state first that we in the Hennepin County Attorney's Office extend our ongoing sympathy and empathy for the Pontfavan family. Nothing that happened today will bring their loved one back, but their actions since his loss and in this courtroom shows class and dignity beyond possibility. They're wonderful, dear people, and my personal hat is off to them. Secondly, I want to say thank you to law enforcement, to the prosecution team so ably headed by Prosecutor Deborah Russell, to Judge Mabley, but also to the jury. It's obvious at the length of this deliberations that it took them a period of time to make decisions on what's a very difficult case. It's a difficult case because we had to prove by circumstantial evidence what was going on in the minds of another person. When you prove evidence to a person's actions, that's much easier to do. But the trying to prove what's going on in their mind is very difficult. And the guilty verdicts in counts 1 and 2 reflect that the jury looked at this very carefully, and in the end, they did justice. This result brings no particular joy or satisfaction to the county attorney's office because nothing will bring Mr. Pontfavan back. But in the end, our job is to prosecute people who violate the law. The jury agreed with us, we proved our case, and we believe justice was done. Questions?
Mike, why do you suppose count 3 not guilty? Do you have any ideas, any thoughts on that?
Well, count 3, gross negligence, is a very, very high standard. It's extremely difficult to prove that. And, you know, we in good faith brought all 3 counts. The last count of careless driving was a throw-in that the judges put in as a lesser included. We knew that gross negligence was hard. We felt that the first 2 counts most reflected the wrongful conduct, and those are the 2 we got guilty verdicts on.
If you thought the gross negligence was hard, why was it the last one you added right before the trial?
Because it fit. It fit with what we think the conduct was. We absolutely believe the jury could have made that conclusion. But because the standard is so high that we think the verdict is entirely consistent with having guilty determinations in 1 and 2.
Mike, you spent a lot of manpower, a lot of resources on this case. What message do you think this sends, if any?
Well, first off, it was person power, because Deborah Russell was our lead prosecutor. Yeah, I read every piece of paper, looked at every interview. I do that on 10 or 15 cases a year because this was such a high profile but a very important case. You know, I think if you're driving a car and you have an accident, the state legislature and all the rest of us believe you have a duty to stop. That clearly is something this censor did not do. And you have a duty to report that accident, at least to tell the police an accident occurred and where it occurred, and to do it by the most immediate methods of communication possible. For most of this, it's our cell phone. And obviously the facts in this case clearly showed there was no report that night, there was no report the next morning. You know, the car was turned in by her attorneys 24 hours later, and she didn't confess to be driving that car for 10 days. I think what it says is that's too long, and I think the message is report your accidents and stop at the scene.
What, Mike, do you think if they could have, as far as the count number 3, perhaps why you got the not guilty was they couldn't pin the cell phone call at the time of the actual impact? Is that something that would have been crucial to getting that gross negligence?
Well, I think it would have helped if the jurors concluded A, she was driving too fast, B, she was on her cell phone, C, she was intoxicated. I don't know what was going on in the minds of the jurors, but you know, I think for the position of justice being met, having a guilty verdict determinations by that jury of count 1 and 2, we are very satisfied that justice was done.
The defense argued there wasn't any direct evidence. What do you think the evidence that you did present that convinced the jurors to cast the verdict they did?
Well, let me just talk about one count, okay?
Okay.
If you talk about the second count, the duty to report. The law says you have to report as quickly as possible by the means of communication most readily available, a cell phone. Well, if you claim you don't know you were in an accident that night, you certainly, the next morning, the testimony clearly showed she was aware there was an accident. Her Mercedes-Benz SUV had $7,500 of damage. Her husband said, look at this on the website. Somebody was killed here. It was a shoe. It caused enough concern that they hired a lawyer, put their car in the garage, gave him the keys, dropped off a check to the lawyer, and went to Stillwater to get out of Dodge. And the lawyer finally, after 24 hours, turned the car over. But not making the simple step of picking up your cell phone and saying, there was an accident on the Riverside exit of 94 on Friday night around 11 o'clock. That's the obligation of the law. And that clearly is what the jurors had to believe in order to find her guilty.
How difficult was it to get a conviction like this when you have a celebrity or the wife of a well-known biker?
You know, we try in our office to see every case, regardless of the economic position of the person, the racial composition of the person, the sexual preference. You know, justice is not supposed to look at that, and we try very hard. And you know, we're human beings. We make mistakes. We were born in certain neighborhoods. I mean, I was born in the Seward neighborhood, and the minority then was the Polish people, and they've gone through 3 or 4 other groups since then. So we all learn from our experiences. But perhaps this case was in the news more than it needed to be, and that sometimes puts additional pressure on us.
On both sides, Mike?
Oh yeah, absolutely. You know, facing you guys every day, I can't come to work. If I came one morning at 7:15, and one of you all was already here at 7:15 in the morning, and I'm going to call his boss and tell him who was here. Anything else, Dan?
Were there ever times in the run-up to this case when the intensely circumstantial nature of it gave you pause or sleepless nights?
Well, yes. You know, when we have the burden to prove by circumstantial evidence what's in a person's mind, that's very hard to do. That's why this particular statute isn't charged more often. You know, if you're having to prove that somebody assaulted someone else, we have whatever you assaulted that person with, and eyewitnesses and blood and, you know, all those sort of things, direct evidence. Here, it's only circumstantial evidence unless the person tells you what they were thinking. And all of us, whether you're Amy Sensor or you're Mike Freeman, we all have a right, a constitutional right not to speak, and she used that as she should. That was her position. Okay? Thank you.
Thank you.